May it please the court, my name is Paul Weiland and I represent the County of San Luis Obispo. I'd like to reserve 5 minutes for rebuttal.
All right. I'll try to help you out, but keep your eye on the clock as well.
Okay, thank you. Judges Nguyen, Forrest, and Van Dyke, in my limited time before you, I will address the three issues that are the focus of our appeal. First is the legal error committed by the district court when it failed to apply the four-part winter test in determining whether to issue a preliminary injunction. The court improperly failed to consider the balance of the equities and the public interest in issuing an injunction that a leading expert declared could be expected to harm.
One thing that's a little ambiguous in your briefing, and I think we all probably understand your argument that TVA versus Hall shouldn't apply when there's ESA species, when there's other ESA protected species. What I wasn't clear about is whether your argument is that they should consider as the last two factors, they should balance the harms to the other ESA species only, or whether somehow that then pulls in all the other things that you normally would consider if it wasn't TVA versus Hall, like the harm to the communities and all this. Now, and I'm speaking only to the ESA claim here. I'm not talking about the state law claim. So sure. Is your argument that the last two factors, the district court should have applied the last two factors for the limited purpose of considering just the harm to other ESA protected species, or that the fact that there's ESA protected species opens things up to where you can consider everything you would normally consider with an injunction on those last two factors?
Yeah, so as to that specific issue, my argument is that once there's species on both sides of the ledger, everything should be considered. But more importantly...
And why would that be? I understand the argument as to why, I mean, just on the language of TVA versus Hall, the purpose the Supreme Court gave for essentially, as we've interpreted at least, truncating it to just the first two factors is that the last two factors are already pre-decided by Congress in that context, because the ESA critters get lots of protection. And I understand your argument to be, yeah, but once you have ones on the other side of the ledger, now that rationale of the Supreme Court isn't true. But I don't understand what the rationale would be that you get to bring everything in, including injury to non-protected humans, and communities and stuff like that.
Yeah, and I want you to clarify essentially the same issue. Is it your position that the Tennessee Valley Authority just doesn't have any application in the context where there are competing species at issue, or is there some sort of presumption at work here?
So I would say, as a threshold, in light of the Starbucks decision from June 2024, our position is that the four factors apply. There is no clear command in the Endangered Species Act, as there was
in all cases. That's your threshold argument. In all cases, and that TVA versus Hill is gone.
Right.
Okay, so I don't know but let's assume for a second we don't agree with that. Then what's your argument after that?
My argument after that, well, I would say if you look at TVA versus Hill, it's a fact-bound case, right? And so one of the things that happened there was this involved the construction of the Tellico Dam. The parties agreed on the case before the court on the facts that the completion of construction operation they believed at the time would result in the extinction of the species. It was also a case involving the federal government and Section 7 of the Act, which allows for consultation.
Right. No, we recognize that TVA has different facts, and I think that's why there's even this discussion of like, okay, what is the rule here going forward, right? Because the rationale in TVA is that that Congress has already made some determinations, and so that's why I raised the issue of presumptions. I'm not sure that Starbucks versus McKinney, is that what you're citing to? I don't know that really answers the question as to whether the last two factors are now back on the table, or is there some sort of presumption here where we can engage in some sort of balancing. I think the district court struggled with the same thing. It recognized that the last two factors may not operate in the same way, but then it did try to attempt to do its best to sort of figure out, well, what's going to happen to these other species. And, maybe in this area, that's where the expertise really come in for you to go to the appropriate authorities who would be in possession of information and sort of assist the county in determining where the balance should really fall.
Yeah, so in terms of the presumption, there isn't clear circuit precedent from any circuit about what to do if there's species on both sides of the ledger, right? And so we've got the two cases that the parties briefed extensively, CBD and the Yurok tribe, where courts dealt with species potentially being on both sides of the ledger. And in those cases, the court contemplated essentially designing an injunction to take that into consideration. But if you look at like the Yurok tribe case, even there where the court frankly has some ambiguous language, the court also considered, for example, the impacts on tribes and tribal water rights. And so in that particular circumstance, there was a weighing that occurred. I think the fault of the judge here was twofold. One, she just didn't consider the interests of the frog. She acknowledged them, but didn't consider the interests of the frog and the goby. And then she presumed that the agencies would be involved in injunctive relief, which they weren't. And we indicated that below that the agencies, which are not parties to this case, wouldn't be involved in shaping relief, and they have not been involved in shaping relief. And so she assumed that what she called the appropriate agencies would help to fashion relief to avoid harm to the species. They're not parties to this case. They haven't been involved. That was a false assumption. And so even if you only focused on the species issues, right, and put aside, for example, the interests of the communities that are losing water on a daily basis, you still come out reversing the lower court. But I would say that once you have species on both sides of the ledger, the whole point of the TVA case, again, part of it is it's fact-bound because the species was going to go extinct there, and the facts showed that in that circumstance. Here, there are no facts like that. The second thing is that when it comes to like how you fashion the relief, there was no mechanism for the agencies to weigh in. The agencies were willing to do so. We reached out to the agencies because we were required by the court to do so, to ask for their guidance. They said they weren't going to participate in the case. They weren't parties to the case.
They said they were not going to participate in the case?
Yes. And they do have the option. Part of the reason they get a 60-day notice under the Endangered Species Act is because they can jump in even before the case starts. They can also obviously intervene in the case if they so choose, or participate as an amicus party. They chose to avoid participating in this case. And the letters to that extent are in the record.
Can they kill a case? Like, I mean, is this like a key TAM action where they can take over or something? The reason I'm asking that is, in theory, you could end up with a kind of an odd, where the environmental group brings like the plaintiff here brings a case, the agency disagrees, and I suppose that in theory they could intervene, I suppose, and present, but you end up with a district court and an environmental group basically issuing something that the agency disagree. You could, in theory, if the agency is not capable, if the law doesn't give them the ability to say we don't agree, we want to shut this down. Do they have that ability, or is it just that they can intervene if they want to?
They have the ability during the notice period to file their own enforcement action, and this is true with some other environmental statutes.
Right, so they can pile on, but I'm wondering if they go the other direction.
But if they felt that the case didn't have merit, the only way they could get involved was through intervention.
Or, I suppose not just that it doesn't have merit, but when you're talking about multiple species, that they're more concerned about one of the other species and the effect, and so they're like, we just don't think you should do A, but there's no way for them to do that?
They could, I think through an amicus brief, or a letter to the court, what they said is, so there's...
Okay, I make sure I'm clear. In theory, they could do amicus. I suppose they could maybe even intervene. What I'm asking, I guess, is but that would be up to the judge. Ultimately, the judge would be the decider there. But there's no way for them to come in and say, no, we didn't bring in enforcement action. We intentionally did not bring in an enforcement action and we disagree with this enforcement action, and we are killing this enforcement. They don't have the ability to do that?
No, not to my knowledge. And here what they said in the letters that they submitted that are in the record was that they weren't going to participate, and that they recommended that the county work with the agencies through the habitat conservation planning process under Section 10, which was a process that was already underway. And so they said that's how they intend to engage with us, not by engaging.
How long is that process going to take to actually get anything going on the ground?
Right now we have an order in place to submit a habitat conservation plan to the court by October 1st. Now, one of the problems with requiring a habitat conservation plan is we can submit that to the court and to the agencies. Once we do that, that doesn't necessarily result in any relief, because then the agencies have an application in front of them. They have to comply with the National Environmental Policy Act by undertaking environmental review before they issue a permit. They have to comply with the consultation provisions in Section 7 of the Endangered Species Act. They have other obligations, for example, under Section
So
106
the,
of
the short answer is it's going to be a while.
Yes.
So what I'm trying to figure out is, I mean, I think you make a interesting argument about that the district court sort of punted on what to do with the competing species and thought that the federal regulators were going to deal with it, and now here we are. And maybe they are, but it's going to be a while. So what do we do about that? My problem is, in terms of the issues that are presented for us, you didn't make that argument. As far as I understand, your argument really is improper legal standard because you didn't apply the full winter analysis. If we disagree with you on that, how do we get to this other issue? You haven't made a separate argument of, and even if I'm wrong about that, the district court erred by not even considering and doing the work to assess whether the preliminary injunction needs to take specific measures to address the competing species.
Well, I do think, and if maybe I can turn to our second claim with regard to Section 5937 of the Fish and Game Code. Pardon me, that's a state.
So, okay, but I just want to be clear. So I understand you want to shift gears to the state claim, and I have some questions about that. But in terms of the federal claim, you agree with me? You didn't make that other
We
argument.
did not appeal on likelihood of success and irreparable injury. We did appeal on the remedy, the scope of the remedy, but we didn't appeal on those issues with regard to the Endangered Species Act claim.
Okay, so you want to turn to the state claim.
I'm sorry, I just want to make sure I understand it. So you're saying you did appeal that the district court didn't consider those things,
Right.
Is that right? Well, what part did you not appeal then?
We said the district court failed to consider the balance of the equities and public interest. We did not appeal that the district court erred in its likelihood of success analysis with respect to the federal claim. We do disagree with the district court's analysis, but there's only so many things that we can appeal from, and we chose three, and those are the three issues that are before the court.
Right, and I think that we're kind of, if I'm sort of discerning my colleagues' questions correctly, I'm sort of struggling with the same thing, like as a practical matter, what are we going to do with it? So if we don't agree with you that all the winter factors are now back squarely on the table, then what do we do with it? Because the district court did say, and I'm looking at the district court's preliminary injunction, it did reference plaintiff's expert Tevin Schmidt, and it talked about whether there's an adequate management process that can avoid harm to other species. So this court was well aware, okay, there's the goby and the red-legged frog that could be impacted here, and is there like a flow or management technique that could sort of balance all of that? So you want us to send it back, but I'm not sure if we don't agree with you on what the rule is. I'm not sure what we're going to say for the district court to do that she didn't already do, which is attempt to mitigate the harm to these other species that may be affected. I'm just trying to think, like, as a practical matter, if we don't agree with you on the initial rule, then what do we do with it? Because the district court did struggle with it already.
Right. I think that, as we've talked about with regard to the public interest and the balance of the equities, even if you narrowed it to just the species, the district court dealt with it by kicking the can down the road and saying, you're going to work with the appropriate expert agencies to fashion a remedy, which we didn't do. Those agencies are not parties to the case and not participating. And so that's a house of cards that just isn't there. And as a consequence, the whole premise for the district court's notion, and also with even respect to the water supply impacts, at one point the district court acknowledges those impacts and says, we can work with the agencies to try and fashion a remedy that's protective of the species and considers water supply. Those agencies are not participating, so we are not working with them to do that. As a consequence, all we have
Right, so
is
you're
the
saying
order.
that essentially the facts on the ground didn't play out the way the district court anticipated,
Yes.
so you want the district court to think about that again?
Yes, certainly.
Okay, you
And-
wanted the state claim addressed as
and
well.
as to the state claim, one of the challenges is that the district court granted on both claims. There's no distinction between the remedies, so we don't know if all remedies were for both claims, or some were for some or some were the other. There's no distinction that was made. But with respect to the state claims, the 5937 claims, we argued both the likelihood of success and the balance of the equities and the public interest. And on these claims, it's important. One of the things that the appellees raise and some of their amici is what the appropriate standard is under 5937. Well, the judge used what's called the historic fisheries standard, which is a standard from the California Trout 1990 Court of Appeal. Both parties had agreed on that standard, and the judge acknowledged that that was the case. So that's the correct standard, and there's no issue of that. We didn't appeal that. But what we appealed from is her clear error in her factual findings. Under the historic fisheries standard, you compare the fishery before and after the construction of the dam. And we submitted facts that demonstrated that the fishery population before the dam in the 50s and 60s was comparable to the contemporary population.
I thought that the record also established that everybody agrees there really isn't historical data. Nobody was tracking this, and to the extent that any data can be pulled, it's speculative.
Right, the data is poor, right? But she had to decide what to do, and what she decided was that there was a decline in the population. But when you look at the State Department of Fish and Game data in the record, that was not only relied on by the State Department of Fish and Game, but also by the National Marine Fisheries Service, and that our expert and plaintiff's expert acknowledged, there is a table with data that shows that the population in the 50s and the early 60s was estimated to be in the low hundreds downwards. And the contemporary population, the best estimate, which is just that, only the best estimate, right, from both plaintiff's expert and our expert, is that the range is in the dozens to hundreds. And where the court erred in particular, where we see factual error here, was that one, she said that the county relied solely, and she used that word solely, on Dr. Hansen's declaration to support our contemporary estimate of the dozens to the hundreds. But Mr. Schmidt came up with an identical estimate, and the National Marine Fisheries Service also had a similar estimate in the record, and those are in the record at 253 for Mr. Schmidt and 5803 for the National Marine Fisheries Service. That's in the dozens to hundreds. The other thing that the court erred on in the same paragraph of the analysis is twice the court said she was not considering giving weight to Dr. Hansen's testimony because he did not provide supporting exhibits for his declaration. This is simply incorrect. This was a mistake by the judge. Those exhibits were extensive. They were attached to the declaration of Benjamin Rubin. They're included in the excerpts of record below and here as volumes 3 to 27 of the excerpts of record. So she thought we hadn't included exhibits to support our experts' views, when in fact we had. That is textbook clear error.
I know you wanted to save a little bit of time. You're down to a little over 2 minutes.
Yes, I think I will do that. Thank you.
Before you sit down, there's a recent California case, is it Kern, that talks about how maybe the analysis is different than what has been assumed under this state statute. And when you come back up, if you would address that, I'd appreciate it.
Sure, happy to.
Good morning, Your Honors. This is Christopher Sproul for Plaintiff Appellee San Luis Obispo Coastkeeper et al. May it please the Court. I'd like to first address the Court's expressed concern about, well, what happens given that the Judge Garnett issued the preliminary injunction premised on, well, if there is some risk of harm to tidewater goby and red-legged frog, that'll be taken care of because the injunction requires the county to consult with the resource agencies and learn their views. And it is true that the court required that those plans about what to do with the flow be submitted to the resource agencies, the National Marine Fisheries Service, and the U.S. Fish and Wildlife Service. And those agencies did respond, well, we're not going to comment on this ongoing case, and we're not going to comment on these work plans. But the thing that's being overlooked is they added, however, we will comment when you provide your habitat conservation plan. The county is under court order by Judge Garnett to file their habitat conservation plan on October 1st. That's a mere 6 weeks away.
Yeah, but you don't dispute, do you? I mean, you read the district court opinion, and it seems pretty clear to me that the judge thought that by sort of deferring on this other species, you know, who's all going to be hurt and how do we manage everybody, She just deferred that question to the agencies with the expectation that the agencies were going to be able to comment on that. If she thought if the judge thought that was going to happen through the critical or the habitat planning that was already being provided, why would that have been said separately?
Well, I think I'm not entirely sure I understand the question, but I think this is the important point, is that her premise, like we'll get guidance from the agencies, is a valid one. It's true it didn't happen yet, and one might say, well, retroactively or retrospectively, maybe that could be seen as a problem. But in fact, it hasn't been. I mean, when my friend opposing counsel comes back up, you can ask him. It's certainly clear there has been no harm to.
Well, I'm more concerned about the legal standard than sort of the practicalities on the ground. I mean, the practicalities sort of inform how we think about this, but the argument we're being faced with is the district court applied the wrong legal standard. And did so because didn't consider harm to other species. Seems, surprising that folks on your side of this case would say, don't consider the other species involved here. Certainly that doesn't seem reasonable, right?
Yeah.
So then we think about what is the legal standard for thinking about other species, and how do we deal with the fact that in this type of claim, we have precedent that says that we only consider the first two aspects of winter, and they don't seem to get at this other species issue. And so the district court here says, we've got conflicting evidence on this. I don't really know what the impact of the other species is going to be, so we're going to have the agencies step in and tell us about that. If that process with the agencies is going to be 2 or 3 years down the road, then we've got an injunction issued to save one species that might have more immediate effects on other species that we can't wait 2 or 3 years to get addressed. So what do we do there?
Yes, because I think the problem or the issue or the defense from our perspective is that it won't be 2 to 3 years before we get the agency's views.
How do we know that?
Because the Habitat Conservation Plan guidance document that the agencies have published, and it's on the internet, I believe it's been referred to in the record, but in any case, it's available on the internet, mandates that the agencies are to work cooperatively with the applicants for habitat conservation plans and incidental take permits under ESA Section 10 and provide them their guidance. And that's actually happening right now.
But the federal regulators don't have to operate on any sort of schedule that the district court might want them to. They're not parties to this case. The court has no jurisdiction over them. And so the district court is imposing an injunction to do certain things to favor one of the species at issue in this story, and hoping that an agency is going to step in and provide guidance on other species involved in this story with no ability to know how that's going to go at all. And we're just supposed to look and see if the district court was looking at the whole picture when it issued its relief that it issued. And that's the problem that I'm figuring, like, where do we look at that? Because here we're sort of left with the district court didn't do that work. And we say that's fine?
Well, no, Your Honor, but this, the district court didn't abrogate this work entirely, certainly. I mean, the district court did carefully and accurately explain the nature of the evidence. The evidence is that there is clear and convincing evidence. She said this is a mandatory injunction. We've got to have clear and convincing showings. We have a clear and convincing showing of harm to steelhead. When it comes to tidewater goby and red-legged frog, we have conflicting evidence, is how she characterized it. Well, those are the facts. What does she do? I mean, she adopted a practical and appropriate solution.
It's a mandatory injunction standard, right? So I have the same concern, which is not so much the facts of this case, but what we're trying to figure out is a novel legal question of what should a district court judge do when you have somebody comes before them and says, hey, we got this one protected species that we have concerns about, but it's clear there's other protected species that might be affected by the relief offered. And I guess we can talk about, time frames in this particular case, but the standard is kind of pretty important because we may be setting that in this case, right? And it seems to me the standard is, does the district court need to figure this out at the time when it issues the injunction, or can it kind of punt on the other species and hope that somehow the parties negotiating or the agencies will step in the gap? And even if you were right that, in 10 minutes the agencies are going to come in this case and solve the problem for us, it just seems problematic to not figure out how things are going to affect I mean, this case does illustrate that in a sense of steelhead salmon eat tidewater gobies, right? They do. They said the EPA says they do. I've got a piece of paper.
They can eat the larvae, not the big fish. But yes, that's true.
I thought tidewater gobies didn't get big.
I'm sorry, Your Honor?
No, the salmon eat the gobies. Then they don't get big, do they? They're teeny.
Sure, we can
And
agree with that.
I think the EPA says, my EPA data sheet I got here says they eat them.
Yes.
I'll take judicial notice of that. So if you got what you wanted, which was 5,000 instead of a dozen or 100 steelhead, actually keep saying salmon, I mean trout, steelhead, then it stands to reason they're going to eat more gobies. And so there is a zero-sum aspect of this, at least. I don't know I'm not a biologist, I don't know the answer, but the question is, do you want a district court saying, okay, we're going to protect the one species and order relief and not figure out, but then order that you just hope that somebody will figure it out? And you can see the concern with that approach, as opposed to saying mandatory injunction. If it's doubtful, you don't issue a mandatory injunction. Let's figure it all out before we issue a mandatory injunction.
Because again, I think the UROC case is very instructive here. I think the district court judge there took the right approach, which was this practical solution. I mean, we have clear and convincing evidence, and that's what this district court judge found. There's clear and convincing evidence of steelhead harm. Conversely, there's some evidence disputed over whether there's an impact to these other species. What should we do in a circumstance
What if it
like
turned
that?
out? What if it turned out that addressing this clear and convincing evidence of steelhead harm eliminated the tidewater goby? I mean, let's assume for a second that would, and we don't know that, but we'll find that out after they're already gone. Is that concerning at all?
Of course it would be, Your Honor, but those aren't the facts. I mean,
We don't know what the facts are. That's the thing. The district court punted on the goby and the frog, and so we don't know. And I guess we're all speculating about when we will know, and when the agency might help figure that out. But doesn't it seem problematic that the district court issues an injunction? I mean, there are certain aspects of the injunction that have already gone into effect, right? More water flow. Some of the stuff has already gone into effect, right?
Yes, it's all gone into effect, and actually that's a very important point. The county glosses over this, but their objections to the preliminary injunction are only to one of the 11 measures, which are the flow releases.
I know, but I'm saying things have already gone into effect, and let's say that those things are super successful in helping the steelhead to do better, but that hurts the tidewater goby, not just in washing away its eggs and stuff, the stuff that was presented, but also in. And we just don't know. We don't know, right? I mean, you said it's not clear. We don't know how it'll affect it.
I think it's unfair to characterize it that strongly that we don't know.
It feels a little bit like you guys care deeply about the trout, but you don't care as much about the tidewater goby.
For rational reasons, because there's very strong, clear, convincing evidence that these
I
steelhead
mean, I
are.
come back to Judge Van Dyke's point. There hasn't been a finding about that. All the district court said is there is conflicting evidence on the impact to these other protected listed species, not just any species out there, but other protected species. And she declined to sort through that or make any sort of decision, and just said the agencies are going to address this and the parties are going to work with the agencies to address this.
But she at least found this, that there is no clear and convincing evidence of harm to to goby and frog.
Well, I find that a little bit funny because you didn't bring a lawsuit about the goby, and they're not, what are they going to do? Come in? You're not about the goby. You're not bringing. And are they going to step in and be like, "Hey, our stream is wiping out the goby"? Nobody's there for the goby. So, at the end of the day, it seems like it's a little unfair to say we don't know what's going to happen with the goby when that's not what this case is about.
But actually, that's not entirely true, Your Honor. We actually are there for the goby. Our complaint does express concern for the goby and the frog as well. I mean, we are concerned with all the species. The preliminary injunction was focused on the steelhead because we were seeking emergency relief. We could only tentatively come to court with a showing of clear and convincing evidence because we needed a mandatory injunction that one of the three species is in dire straits and in
Do
need
you
of
know,
urgent action.
are you guys convinced? I guess I'm trying to figure out, so you care about the goby, but are you convinced the goby won't be harmed at all by any of these measures? Is that, but the court just didn't know, but you're convinced, or?
Yes, and it's not just us, Your Honor, it's the agencies as well, and that's another point that's been glossed over, is we don't have a total vacuum of what the agencies...
This reminds me a little bit of yesterday. I think, you say how can it be true that the agencies are convinced when they've reserved the ability to weigh in on that? I don't
Because
think we can put in the agency's mouth that they think the goby's going to be just fine.
No, I'm not putting it in their mouth, Your Honor. It's in the record. The agencies have weighed in the past. The National Marine Fisheries Service did comment on the 2004 draft Habitat Conservation Plan, and the agencies have been working with the county for decades, and they have indicated what they think needs to happen. They've said there needs to be more water released for steelhead. They've gone on the
Let me
record
ask you this,
saying
counsel.
that.
If we conclude that TVA doesn't have direct application to this situation where there are competing species that are potentially harmed, and that some sort of balancing needs to be done, do we then send it back to the district court to consider that more explicitly? Because you seem to argue, well, she did think about the other species, and I think she did, but I'm not sure she did too much about it other than lean on the expertise of the agencies. And that's an understandable instinct. You know, we're not, at least speaking for myself, I'm not equipped to handle these sort of like expert evaluations, even assuming that there's expert evidence on each side. But at the same time, the winter analysis has to be engaged in. So do we send it back to say, well, you know, there are competing species here. You've got to grapple with it as best as you can, balance the equities better than the record that we have. And if the parties aren't satisfied, I guess we'll see the case again.
Well, to vacate the preliminary injunction in its entirety would be certainly an overreach on this court's part, in that the county itself is only arguing that there's a conflict between the needs of the species with respect to one of the 11 measures ordered by the court. The other measures are important for steelhead survival and recovery, as the district court found, and at least those measures should remain in place, even if the court is convinced, well, there wasn't enough analysis by the district court as to the...
You're saying that it can be severed, or the analysis can be separated.
Absolutely, they can, and they are. They are by the county's own argument, which makes complete sense. Because the other measures, things like, let's remove predators that eat steelhead from the watershed. That can't possibly hurt tidewater goby or red-legged frog. Those same predators eat those species as well.
You said that the district court made a finding there was no clear evidence. I think you said clear evidence.
Clear and convincing.
Clear and convincing. Where in the record is that?
She did. It's true. She didn't say that explicitly, but she did.
I don't think she said anything about resolving the conflict of is there or is there not harm to these other species. I think she said nothing about that. I think she acknowledged that there was evidence going both ways and said the agencies are going to sort this out. So if I'm wrong about that, I want you to point me to the record.
No, I agree with that, but it would only be by implication,
Okay.
number one. And
let's go to the California claim, because before you run out of time, I have a couple of questions about the California claim. Do you agree with your friend on the other side of the aisle about what the definition of good condition is for this case?
No, Your Honor, and you don't have to take the plaintiff's word for it. You should rely on what does the state of California think about the interpretation of its own laws.
So I understood your opposing counsel to say that in this case, the parties proceeded with the understanding that the definition from California Trout 2 was going to apply, and that wasn't challenged. You're saying that's not true?
That's not true. We didn't say that the standard for interpretation of California Fish and Game Code 5937 is you just do a head count of how many fish were in the stream before the dam was built and how many are there today.
Okay,
it's true.
Okay, that makes sense, and I'll go back and look at the record and see if I can find that is sort of how this case progressed. My follow-up question then is, I've spent a lot of time trying to figure out what good condition means in that California statute, and as far as I can tell, that one statement in California Trout 2, which is sort of oddly placed in that opinion, is the only statement from a California court that's like directly on point. Is there some other statement from a California authority about how we should read good condition other than at the regulatory level?
No, Your Honor, not that I'm aware of, not at a regulatory level, but I
Then
think
what do we do? Like, should we certify this question of the California Supreme Court? What does this mean?
I think that actually is certainly an option available to the court. It might well be a good one. I would also point out, as I think the court is aware, is the California Supreme Court has taken up the Bring Back the Kern case on review. You referred to the Kern case earlier, and so
how does that impact the question I'm asking you about what does good condition mean? How does the Kern case impact that?
Well, the California Supreme Court should probably tell us when they issue their decision on the Bring Back the Kern case. But I only read Kern very quickly, and my takeaway from it at this point is that Kern is saying that even if you had a situation where the standard under this California statute, the number is escaping me. 5937, Your Honor?
5937 that has this good condition language. Even if you had a situation that satisfied that standard and you should take action for that purpose under that statute, that you nonetheless still have to balance all uses of water for reasonableness and beneficial use. So I'm not sure if that's what Kern is about, that it's going to help us figure out what the statute language of good condition means.
That is entirely possible. You're correct that was the issue that certainly was the focus of the Bring Back the Kern case, and it is the issue that the California Supreme Court has granted review to resolve.
Kind of related to the question Judge Forrest is asking, I too was like, what does this mean? And I couldn't get much traction from state law. So how, if at all, does that weigh into the mandatory injunction standard in the sense of, as you know, you're not supposed to issue a mandatory injunction. It's sort of a do no harm principle as I see it. Like, you don't change the status quo unless you're confident that you're not going to do any harm or make it worse. And so if we can't figure out what the good condition means exactly, not just exactly, but like what does it take into account? Does that feed into federal courts not issuing a mandatory injunction? You see how in theory, you could say, well, I'm not going to issue if I was a judge sitting there, I'm not going to issue a mandatory injunction because I'm not sure what this means.
Well, I think that would be a bridge too far, Your Honor. I mean, that would be ignoring the statute and the intention.
No, it wouldn't be, because in theory the case continues, right? We're talking about a preliminary. We're talking about you could at least maybe I should modify my question to be preliminary injunction, a mandatory preliminary injunction. So saying I'm not sure I'm going to issue this now because I don't know what it means. Come back to me with more. I don't know.
But again, preliminary relief is meant to prevent irreparable harm, such as extinction of a species. If the species was going to be wiped out unless some affirmative mandatory action was taken, it would be ignoring the intent of the legislature to say, well, we're not going to require someone to take that action because we can't figure out what good condition means. I mean, the law presents all kinds of difficult questions for the courts to resolve. What's the due care due of a reasonable person? And yet the courts are.
I get your point that eventually you got to figure this out, but that doesn't. But there is a difference between that and saying, but I'm going to issue a preliminary injunction right now, a mandatory injunction changing the status quo. You just don't think there's a relationship between it. You got to rush to make the decision and get that preliminary injunction out, even if you're not sure what good condition means.
No, I wouldn't go that far either, Your Honor. I mean, I would say, yes, I would agree if this is where the court is going, that extra caution is called for when the statutory term is ambiguous, but that doesn't mean disregarding it entirely. I think the court is still obligated to do its best to give meaning to that term and to do such things as look at, well, what have the resource agencies that are in charge of administering this, what do they think? I mean, again, under Loper-Bright, you don't have to defer to them, but under Skidmore, you at least consider them.
This is all California law, so what does California think about a regulatory interpretation?
That we've briefed that, and it's been made clear. I mean, the California Department of Fish and Wildlife, the California State Water.
I understand that the California regulators have a position on what that means. What I'm asking is, under California law, what do California courts do with that? Do they give that binding weight? Do they give that deference? You know, I'm asking the Loper-Bright question at the California level.
Yeah, my understanding of California law is that there is deference given to state agency interpretations of the California statutes that they administer. I think I don't know the exact doctrine, but I think it's certainly not Loper-Bright, and it's certainly at least Skidmore, that they do give consideration. And if the court decision would be happy to submit supplemental briefing on that, and neither party has briefed that specific question.
Thank you, counsel. You're over time. We appreciate your argument.
Thank you very much.
Okay, there's a lot to cover.
Counsel, let me ask you this. We've been talking a lot about the steelhead versus the goby. What about all these other aspects of the preliminary injunction? Counsel is saying that the challenge on appeal is really narrow.
That's just incorrect as a matter of fact. You can look at the brief and see we challenged the injunction as not narrowly tailored. We gave a number of examples.
Well, so jump in on that. I mean, one of the things that the injunction requires you to do is to go through this permitting process for an incidental take permit, which for whatever reason I can't figure out the county has never bothered to do. So would you say that if we think that there's a problem in balancing species, that we should undo that part of the injunction?
You can, but the thing is that doesn't just go to the flow releases, for example, because one of the things that the court required is habitat restoration. When you're restoring habitat for steelhead, the species overlaps with the red-legged frog. If you go in and dredge the habitat, for example.
Well, if we know that the agency is going to be participating in the permitting process and in that plan process, and we know that they're already aware of this issue of multiple species because they've been asked to get involved and have said no. So on that issue and that aspect of the preliminary injunction, should we be concerned about multiple species risks?
As long as the time is afforded for the process to take place to consult with the agencies. But this gets back to one of the problems with the injunction being narrowly tailored to irreparable harm during the pendency of the action. The point made by Judge Van Dyke was that a preliminary injunction is an extraordinary remedy, right? That's what Winter says, that's what Starbucks says.
So you're asking for the entire injunction to be vacated?
Yes.
Haven't some of this been implemented?
Yes.
What about
there
the
are a number
final
of plans
predator?
that have been implemented.
So the final predator removal plan was supposed to be adopted by April 2025. Was that done?
We have adopted a number of plans. There is then a whole process to implement those plans. And let me just say with regard to...
So I'm trying to figure out, you're asking that the entire injunction be undone, but some of that order has already been implemented.
Right. I'd say if you vacate and remand, then the court has many options in front of it. One is to have a new preliminary injunction hearing. At this point, there's a lot, fact evidence has closed in the case. We aren't at a point where we have no complaint, or we only have a complaint. And so there's a lot more information that the court can consider.
So go back with a newer record or a more current record and hash it out before the district court?
Yes, certainly that's the case. And if I could just get to, you had asked about bring back the current, and I haven't been able to get to it, but I would say the most important thing is because we are arguing clear error, both with respect to likelihood of success and with respect to the balance of the equities and the harms, those are factual errors. The court said specifically on the issue of the 5937 claim, right, that both parties concede that sufficient water to keep steelhead in good condition entails enough to restore the historic fishery. So that's the test that was applied. If the court wants to apply a new test, that's fine, but it didn't apply that test. Then you have to vacate for that reason. We didn't appeal on that, and neither did the other side. But if you want to certify that issue, or if you want to raise that issue sua sponte, you can.
Do we need to park this case for Kern to get decided?
I don't think you do, and certainly not the other issues in this case. The other thing I wanted to say, the one more comment with respect to the 5937 claim, is in the balance of the equities and the public interest test, again, the judge had clear error. And let me just point to two ways that's the case. If you look at that 5937 section on balance of the equities and public interest, the judge doesn't mention the frog and the goby at all, nowhere. The other thing is the judge talks about water supply impacts but doesn't mention the declaration of Jared Emery, who the county employed to provide a declaration on the water loss as a consequence of the flow restrictions. That loss was estimated at 2,100 acre feet for a year as a minimum amount of loss. So since the injunction's been in place, the county has already lost 475 million gallons of water. Once we release that, it's gone. When we have it stored, we can use it for the communities in the county. Once we release it, it's gone. That's irreparable harm, in my view, and that's evidence that the court just didn't consider.
Just one clarification. So is the upshot of that in a wetter year, for lack of, that's probably not a scientific term, in a wetter year that may not affect things, but in a drier year is when you could get in, like, so this plan says you got to release water. You don't know how later in the season whether it's going to be dry or a wet year, and if it's a,
Yes.
if it turns out to be super dry, like we had drought in past years. I don't know what the current status is, but if we got a really dry year, that's what these communities are worried about. Is that?
Yeah. So the communities. I'm
just trying to figure out, and I don't want to take too much time because I know but I'm just trying to figure out. It's not. Is the idea that it will necessarily every year affect the communities, or is it sort of a depend on what the weather's going to what the weather's going to be like, whether it's a dry year or a wet year, and if it turns out to be a dry year, we could be impacted. I'm just trying to figure out.
So the 475 million gallons that we've released that we couldn't use, that's gone to the communities. The communities still pay for all the infrastructure to have the dam, and now the reservoir is lower. If we have a wet year, it'll refill, to your point, but we live in an environment where we know we're going to have a boom and bust cycle, and the whole California water infrastructure is built on the basis of the need to store water in the good times so you have it in the bad. But once you release that water, it's gone.
All right. You're over time unless my colleagues have additional questions. Thank you very much to both sides for your argument this morning. It's been very helpful. The matter is submitted, and we'll issue a decision in due course. The court is in recess until tomorrow morning.
Thank you.
All rise.